My dear friends, now I am taking the next question of paper K5002 LLB. The question is, discuss fully the law relating to tender of pardon to an accomplice. The law relating to tender of pardon to an accomplice is contained under section 306 to 308, which is under. First point, with a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offense to which this applies, the Chief Judicial Magistrate or a Metropolitan Magistrate of first class at any stage of inquiry or trial may tender a pardon to such person on condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offense, and to every other person concerned, whether as principal or abettor in the commission thereof. My dear friends, in the first point, the first class magistrate can grant a pardon to any accomplice or grant a tender of pardon to any accomplice among the accused. So, the accused, which will be got this facility, have to help the case or in deciding the case truly. So, this is the first point. Now I am taking second point. My dear friends, second point. This section applies to A. Any offense triable exclusively by the Court of Session or by the Court of a special judge appointed under Criminal Law Amendment Act 1952. B. Any offense punishable with imprisonment which may extend to 7 years or with a more severe punishment. Second condition. Now, third point. Every magistrate who tender a pardon under subsection 1 shall record his reason for doing, shall record first A. His reasons for doing so. Second, it means B. Whether the tender was or was not accepted by the person to whom it was made. In third point, my dear friends, there are two conditions A and B. His reasons for doing so, why he is doing so, whether the tender was or was not accepted by the person to whom it was made. The judge have to confirm the tender is accepted or not. Fourth point, every person accepting a tender of pardon made under subsection 1, A point, first, A, shall be examined as witness in the court of the magistrate. This is the condition shall be examined as a witness in the court of the magistrate. B. Court of the magistrate, and also taking cognizance of the offense and in the subsequent trial. Second point B. Shall, unless he is already on the bail, be detained in custody until the termination of the trial. My dear friends, these are the points. In second point, there are two conditions A and B. In third point, also there are two conditions A and B. In fourth point, also there are two conditions A and B. So, now I am taking fifth point. My dear friends, fifth point. Fifth point is where a person has accepted a tender of pardon made under subsection 1, made under subsection 1, made under subsection 1 and has been examined under subsection 4, the magistrate taking cognizance of the offense shall, without taking any further inquiry in the case. First point A. Commit is for trial. In A, first point is, again, first point, to the court of session of the offense is triable exclusively by that court, or if the magistrate taking cognizance is the chief judicial magistrate. In A, second point, to a court of special judge appointed under the Criminal Law Amendment Act 1952, if the offense triable exclusively by the court. These are the 2 points of A. Now point B. In any other case made over the case to the chief judicial magistrate, who shall try the case himself. My dear friends, this is the fifth point, where a person has accepted a tender of pardon made under subsection 1 and has been examined under subsection 4, the magistrate taking cognizance of the offense shall, without taking any further inquiry in the case. There are 2 points A and B. In A, there are 2 sub-points. So, I have made these 2 points clear. So, now I am taking the next point of this question, the object of the tender of pardon. What is the object of this tender of pardon? I am going to discuss with you in the next point. My dear friends, object of the tender of pardon. The object of tender of pardon, this is the object of tender of pardon. First, the object of tender of pardon to an accomplice is to allow pardon to be tendered in case where a grave offense is alleged to have been committed by several persons, so that with the aid of the evidence of the person pardoned, the offense could be brought home to the rest. This is the first condition of this object. Second, Ordinarily, a court must seek corroboration of the evidence of an approver before convicting a person on that evidence. The court must satisfy itself that the statement of the approver is credible in itself, and then it must seem the corroboration of the approver's evidence with respect to the part of the accused person in the crime. This is the second point of the object. Now, third, the appreciation of the approver's evidence must satisfy double test. This is the double test. What is double test? First, his evidence must show that he is a reliable witness. First condition, his evidence must show that he is a reliable witness. And then, second test, his evidence must receive sufficient corroboration. This is the second condition or the second test. So, my dear friends, this is the object of the tender of pardon. And now, the next point is power to direct tender of pardon. Power to direct tender of pardon. Next point I am taking. My dear friends, now power to direct tender of pardon. According to section 307, at any time after commitment of case, but before judgment is passed, the court to which the commitment is made may, with a view to obtaining at the trial the evidence of any person supposed to have been directly or indirectly concerned in or privy to any such offense, tender a pardon on the same condition to the such person. Now, this is an example I am giving you. It was held in Devendra versus State of Tamil Nadu 1998 that under section 307, once a case is committed for trial by a session court, then the only court that can tender a pardon to an accused is the court to which the commitment has been made. My dear friends, these are the conditions in this paragraph. Who can direct the tender of pardon, or who has power to direct the tender of pardon according to the section 307? Here, this is the case of direct of tender of pardon. Direction is who can give the direction or who can direct tender of pardon. So you have seen in this Devendra versus State of Tamil Nadu under section 307, power to direct tender of pardon in this case. Now I am taking next withdrawal of pardon. My dear friends, last point, withdrawal of pardon. According to section 308, trial of a person not complying with condition of pardon, where in regard to a person who has accepted a tender of pardon made under section 306 or 307, the public prosecutor certifies that in his opinion such person has either willfully concealing anything essential or by giving false evidence not complied with the condition on which the tender was made. Such persons may be tried for the offence in respect of which the pardon was so tendered, or for any other offence of which he appears to have been guilty in connection with the same matter, and also for the offence of giving false evidence, provided that such person shall not be tried jointly with any of the other accused, provided further that such person shall not be tried for the offence of giving false evidence. My dear friends, the last point is withdrawal of pardon. The pardon can be withdrawn because if he did not or do not fulfill, or if he does not fulfill the condition of the pardon or the condition of the tender of pardon, the pardon may be rejected or may be cancelled, or that accused may be tried in the case as other accused are tried. So, this is the condition of withdrawal of pardon. If he does according to the conditions, he may have this tender of pardon. If he does not fulfill the condition of tender of pardon, the pardon may be rejected and he may be taken as like other accused in the case. This is the last point, my dear friend. So, this is a very important question. I think the concept of this question is clear to you. I have tried up to my level best to try or to explain this question. So, in the last, my dear friends, I want to make a request to you, please subscribe the channel. I shall be very thankful to you.